Welcome back to Clear Probate, where we make Florida probate and estate planning easy to understand. If you've been named as an executor, or as we call it in Florida, a personal representative, one of your most important jobs is preparing the probate inventory. This isn't just a formality. The inventory is the backbone of the probate process. It's how the court, creditors, and beneficiaries know what the estate contains and how much it's worth. If it's done incorrectly or late, it can cause delays, disputes, or even liability for the personal representative. In this video, we're going to cover what a probate inventory is, the deadlines you must follow, exactly what must be included, real examples of assets, common questions families ask, and practical tips for getting it right. By the end, you'll have a clear roadmap to preparing an accurate Florida probate inventory. The probate inventory is a detailed list of all assets owned by the deceased person at the time of death that are subject to probate. Think of it as a snapshot of the estate. It includes not only a description of each asset, but also its estimated fair market value as of the date of death. The inventory helps the court supervise the process, ensures creditors know what resources are available to pay debts, and gives beneficiaries transparency about what they may inherit. In Florida, preparing and filing this inventory is one of the official legal duties of the personal representative. It's not optional. It's required under Florida probate law. Now let's talk timing, because deadlines are critical. Under Florida law, the personal representative must file the probate inventory with the court within 60 days of being issued the letters of administration. Those are the official documents from the court that give you authority to act as personal representative. This means that as soon as you're appointed, the clock starts ticking. If you miss the 60-day deadline, the court can take action, including requiring explanations, imposing penalties, or even removing the personal representative. Extensions are possible if you have a valid reason, but it's best to get started early to avoid unnecessary stress. The inventory must include all probate assets. That means any property that does not pass automatically to someone else outside of probate. Let's break this down into categories. Real property houses, land, and condos owned solely by the deceased, or without survivorship rights. If the property is the homestead, it still must be listed, though it may be treated differently under Florida law. Bank accounts, checking, savings, and certificates of deposit owned solely by the deceased. Joint accounts with rights of survivorship usually pass automatically, but you should still verify ownership before excluding them. Investment accounts. Brokerage accounts, stocks, bonds, and mutual funds without a designated beneficiary. Retirement accounts like IRAs and 401(k)s with beneficiaries generally avoid probate, but if no beneficiary is listed, they must be included. Personal property vehicles, boats, jewelry, furniture, art, and collectibles. Don't underestimate personal property. Its value can add up quickly. Business interests ownership in a small business, LLC, or partnership. These often require appraisals to determine fair market value, debts owed to the deceased. Loans or promissory notes where others owe money to the deceased, other assets. Digital assets like cryptocurrency or online accounts. Life insurance proceeds if payable to the estate. Each item must be listed with a reasonable description and its estimated value on the date of death. Appraisals are often needed for real estate, businesses, and valuable personal property. Let's go through some practical examples so this feels less abstract. A house in Miami worth $350,000. Even if it's homestead property and protected under Florida law, it still belongs on the inventory. A checking account at Bank of America with $15,000. A 2018 Toyota Camry valued at $12,000. A coin collection appraised at $5,000. A 50% ownership interest in a family restaurant valued at $40,000. All of these must be included in the inventory because they are probate assets. Now, here are items you generally do not include. Life insurance policies with a named beneficiary. Retirement accounts with designated beneficiaries. Joint bank accounts with survivorship rights. Property held in a trust. These are non-probate assets and pass outside of probate. But as personal representative, you'll want to double-check documents carefully to be sure. Common questions. Families ask, what if I don't know the value of an asset? You can use appraisers or professional valuators. For example, a real estate appraiser can provide the fair market value of a home. Estimates should be as accurate as possible since they affect taxes, creditor claims, and distributions. Do I have to list household items like furniture or clothing? Yes, if they have value. Everyday items may be grouped together with an estimated total value, but significant items, like antiques, art, or expensive jewelry, should be listed individually. What if the deceased owned property in another state? Out-of-state property is not part of the Florida probate inventory. It must usually go through an ancillary probate process in the state where it's located. Do I need to update the inventory? Yes. If new assets are discovered after the initial inventory is filed, you must file an amended inventory with the court. Can beneficiaries challenge the inventory? Beneficiaries may question values or items included. That's why accurate descriptions and professional appraisals are important to prevent disputes. Practical tips for executors. Start immediately. As soon as you're appointed, begin gathering bank statements, deeds, titles, and other documents. The 60-day deadline arrives quickly. Stay organized. Create a spreadsheet or folder system to track each asset, its location, and its estimated value. Use professionals. Appraisers, accountants, and attorneys can help ensure accuracy and prevent mistakes. Communicate clearly. Keep beneficiaries updated about what's being listed. Transparency helps avoid family disputes. Don't forget debts owed to the estate. If someone borrowed money from the deceased, that's an asset that belongs in the inventory. Now I'll tell you a little story. Let's take the example of Karen, who was appointed as personal representative for her father's estate in Tampa. At first, she thought it would be simple, just the house and a couple of bank accounts. But as she dug deeper, she found a small investment account her father had opened years ago, an old loan he made to a family friend, and a collection of rare baseball cards. Karen worked with an appraiser to value the house and collectibles, listed all the accounts with accurate balances, and filed the inventory on time. When a distant relative questioned the values, Karen was able to point to professional appraisals, which satisfied the court and the beneficiaries. Because she prepared carefully, the probate process moved smoothly, and the estate was settled without major conflict. Now you know what a Florida probate inventory is, the deadlines for filing, exactly what must be included, and how to handle tricky assets. Preparing an accurate inventory is one of the most important steps for a personal representative, and getting it right helps ensure the probate process goes as smoothly as possible. If this video helped you, subscribe to Clear Probate and let us know your thoughts in the comments. We read everyone. Here's a question for you. What do you think is the most challenging asset to inventory? Real estate, personal property, or business interests? Share your thoughts below, and we may cover your question in a future video.
If this helped bring clarity to your situation, hit that like button and subscribe for more guidance.